criminal law and criminal procedure. It's a topic taught through two courses at law schools, and we're going to try to do this. We're going to try to do this in 2 hours or less. So criminal law is not much different from Korean criminal law, at least the general structure. Killing another human being is a crime in Korea. So is killing another human being in the United States. So the studying criminal law in this class will be limited to learning the terms that represent similar concepts in Korean criminal law. So we start with preliminary or vicarious crimes. Preliminary crimes, crimes that have not taken place, crimes that are in the process of taking place, right? So solicitation, repeat after me, solicitation. What do you think this is, solicitation? In Korean. You did criminal law, right? Okay, what do you think solicitation is? Solicit, ask, right? 교사, okay? All right, conspiracy. Or it will be like this. You will go for everything. Because there is almost one-to-one correspondence between Korean law concepts and American law concepts. Conspiracy. 음모, 모의, right? Okay. So conspiracy takes two people, right? Attempt. Attempted murder will be? Yes, Misu. Okay. Accomplice. 공범. Okay, right. So, even accomplice, 뭐 사후 공범 뭐 다 있는 것처럼, accomplice after the fact, accomplice before the fact, all the categorizations apply there. And then the crimes can be categorized into these three big categories. Crimes against the person. Murder. Repeat after me. Murder. Manslaughter. Assault and battery. False imprisonment, kidnapping. So, you know what murder is? What do you think manslaughter is? 그런데 과실치사만 포함된 게 아니라 조금 달라요. 뭐랄까, 정신적으로 극도로 이렇게 흥분된 상태에서 의도하지 않고 그러니까 의도는 했는데, 그러니까 의도적인 살인 중에도 참을 수 없이 극도로 흥분된 상태에서 벌이는 살인도 미국 법은 manslaughters로 들어가요. 네, murder가 아니고. 어떤 사례가 있는지는 좀 이따 얘기를 할게요. Assault and battery. 이건 뭔지 알 테고, 폭행, 또는 이제 총을 쏜다거나 이런 것들은 이제 assault and battery에 들어가고요. False imprisonment, kidnapping 이것도 알 테고. Okay, crimes against personal properties, larceny, theft. Okay, same thing. What is it? Larceny, theft. 네, 절도 좋습니다. embezzlement. 오케이. robbery. 네, 강도. 네. extortion. 공갈. 네. 이게 이제 조금 다른 부분인데, 우리나라는 협박, 강요, 공갈 다 있죠. 근데 미국은 협박을 범죄시하는 경우는 없는 것 같아요. 협박 자체를. 그러니까, 협박 자체를 범죄시하는 경우도 없다고 말할 수는 없고, 어찌됐든 그렇게 주요 범죄로 보고 있지는 않고, criminal threat이 있긴 있으니까, 어찌됐든 그 extortion을 중심으로 처벌이 이루어집니다. 자, crimes against real property, burglary. burglary는 뭘 것 같아요? trespass with intent to commit a felony. felony는 뭐예요? 중죄죠. 중죄를 저지르기 위해서 침입한 경우는 별도로 또 처벌을 해요. 네. 그래서 burglary, 왜냐면은 침입을 했는데 뭔가 훔치려고 침입을 했는데 훔치지 않고 도망갔다. 그래도 burglary. 네. 그리고 arson, 이건 뭔지 알 테고, 방화. 네. trespass, 이건 이제 주거 침입. 그래서 똑같은 주거 침입인데 중죄를 저지를 의사를 가지고 들어왔냐 안 들어왔냐에 따라서 버글러리가 될 수가 있고 트레스패스가 될 수 있고. 자, 넘어가 봅시다. felony, misdemeanor, civil infractions. 자, felony, misdemeanors, misdemeanor를 경범죄라고 번역을 하게 되면 오해가 많죠. 우리나라 경범죄는 어떤 것들이에요? 노상방뇨, 무단횡단, 이런 것들, 4만 원, 5만 원 범칙금 내는 것들이 그 경범죄거든요, 우리나라에선. 근데 미스디미너는 그런 게 아니라 그 법정 형량이, 그러니까 최고 형량이 1년 미만인 것들을 다 미스디미너라고 해요. 그 최고 형량이 1년 넘으면은 전부 다 펠런입니다. 그래서 우리나라로 따지면 경범죄에 해당하는 거는 civil infraction이라고 보통 불러요. civil infraction. 왜 civil이냐면 criminal은 감옥에 보내야 그걸 criminal이라고 보내는데 그냥 돈 내고 끝낸다라고 해서 civil infraction이라고 부릅니다. Okay, constitutional law. Federal government is a limited government with enumerated powers which did not include general police power to ban traditional crimes. 90% of criminal cases done by state prosecutors, district attorneys elected. 이건 써놓 있는 대로 헌법을 배우려고 하는 게 아니라 그 헌법 때문에 이제 어떤 문제가 발생했냐면 So I said federal government is a limited government, right? It exercises only those powers that are enumerated in the Constitution as federal powers, right? So there were many crimes that the state court could punish even before the law was passed, right? But because the state had just general police power, right? The general power to protect people's lives and properties. But federal government could not exercise powers unless that power is specifically listed in the Constitution. And if you look at the enumerated powers, there's nothing about passing criminal laws to protect people's lives and properties. So there was no general police power that was turned over to the federal government. So most of the crimes being committed are state crimes. Only the big ones, only the important ones that the federal legislature had a chance to pass a criminal law on, right, are being charged as federal crimes. The most representative of those crimes are drug-related crimes. And guess under which power the federal legislature passed a law prohibiting exchange of drugs or selling and buying of drugs? Huh? I mean, if you look at the Constitution, itself, it doesn't list, criminal prosecution as one of the powers that the federal legislature could pass a law on. But there are other powers, right? Raise army and navy, issue money, issue postage, raise income tax, regulate interstate commerce, regulate commerce among the states, right? Under which of the powers do you think the federal legislature made criminal laws? Interstate commerce power. Okay. I told you that, and it's also in the first lecture manuscript, that interstate commerce power is used often to justify the laws, to justify the many of the federal laws. So let's say someone was caught, raising and selling marijuana, right? And if the person could really prove that his raising and using marijuana, the effect of that activity was limited within the state, and he didn't sell outside the state, then it's not a federal crime. Because a federal law originates from its power to regulate commerce. What is commerce? Goings and comings, right? The goings and comings between the two states, between different states, unless that is involved, commerce power is not invoked. So 90% of criminal cases are done by state prosecutors, and they are called district attorneys. Repeat after me, district attorneys. Okay. And due to double jeopardy rule, the prosecutors do not have a second chance, has to choose a correct crime to prove. Double jeopardy means it's a rule against double jeopardy. So a person will not be in the risk of prosecution twice for the same crime. Okay? So we're not going to go too much detail into that. Murder and manslaughter. Murder is defined as killing with malice. And what is, yes?
Can I ask a question?
Sure.
The FBI?
Sure.
On what power do the FBI, I mean, in the crime shows, if there is a murderer who killed several people in one state and several people in other state, don't the FBI sort of take command? They can take command, don't they?
Sure. I mean, if someone from outer state comes and kills a person in other state, and if they are involved in that, if there is a transportation, right, of a person across the state boundaries, then there is interstate commerce, And
So that's also based on interstate commerce.
sure, yeah, everything. So there is a federal crime of murder, but again, in the statute, there is a requirement of interstate commerce. That's why most crimes are just prosecuted as state crimes. I mean, most murders are prosecuted as state crimes. Because murder, just killing another person takes place within the state boundary. So anyway, murder is killing with malice, and what is malice? Intent to kill or injure. So the perpetrator has to have intent to kill or at least injure, right? Or there has to be wanton conduct. What's wanton conduct? Wanton conduct. So no intent to kill or injure, but just reckless, right? Reckless to the risk of killing somebody, right? So let's say there's a crowd of people standing at the bus station, and as you pass by, you just shoot a gun at the crowd. And yes, you didn't intend to kill any specific person, but you are just reckless to the risk of killing somebody, right? Or you know that there's a crowd of people downstairs and you just throw a large brick, right, over the, out the window. And you know it's going to kill somebody, right? You didn't intend to kill anyone, but you acted with reckless disregard. So, the judges use the term like depraved heart, right? 사악한 마음. 이제 그런 면을 쓰는 경우도 murder에 들어갑니다.
Does it include action part? So just the action.
Of course. All of this has to have a killing. There has to be death.
No, I mean, 그러니까 만약에 이걸 자기가 치우지 않으면은 예를 들어서
I mean action versus non-action.
Yeah.
Well, I think that it depends, right? Let's say you are driving a car, and if you fail to hit the brake, right? Is that action or non-action? Is that non-action? Because you failed to hit the brake? Or is it action because you are driving, right? I think that you have to look at the,
For example, if an adult let a kid play in a
swimming pool and
he drowns and he was in charge of the kid, does that constitute a wanton conduct?
well, good question. I don't know. I'm not a specialist in criminal law. That I don't know. So, the Olympic swimmer example, right? Letting the child drown when he knows that he can easily save the person. Well, I think that in that case, it will not be charged as murder. So, well, okay, having gone a very roundabout way, I think I'm now convinced that yes, it takes affirmative action. I mean, if tort requires affirmative action, criminal law, crime, of course, requires even more affirmative action. So in that case, the Olympic swimmer will not be charged with murder, will be charged with something else.
But how about letting the children intentionally?
Mm-hmm.
He had intent to kill the child, but
Mm-hmm.
didn't do anything intentionally.
Mm-hmm.
What about this one?
Well, interesting case. I think it's a very interesting case. I think it really depends. If he was involved in creating the risk, right? If he was originally involved in creating the risk, I guess that will be considered the action. It will be different from Olympic swimmer, right? Just sitting idly by the pool, having nothing done, and the child just starts drowning, right? But if he was involved at all in creating the risk and he knew about the risk, then he will be charged with wanton conduct with depraved heart.
Is there any Korean middle term that you
I don't know. 미필적 고의는 manslaughter로. Okay. Killing during felony. So, commission of a felony, the theory is that commission of felony increases the risk of death. So, if you kill someone during commission of felony, then it is considered murder even if you didn't intend it. Right? So, let's say you are committing burglary or arson, right? You set something on fire, that's felony. And you didn't intend to kill anyone because, you didn't know that there was somebody inside. But if somebody died, because the felony is dangerous activity, even if your intent did not reach killing, you are assumed to have intended the consequences, right? So it's called a felony murder. Okay.
The felony has to have succeeded, or
It doesn't have to. In commission of a felony, right? And then there are these important terms that you hear a lot in your mid-watching. First degree murder and second degree murder. So anything that's not first degree murder is second degree murder, right? So the term second degree murder is not used often because if you just say murder, then it's usually second degree murder. If you say first degree murder, then we are talking about premeditated and deliberate murder. Premeditated. So there has to be premeditation. There has to be planning. And the action has to be deliberate. It should not be by accident. Because of the requirement of a premeditation, so it's more than intentional. Okay? It's a higher state of mind than just being intentional. There has to be premeditation. And because of the requirement, the prosecutor has to prove a motive. If the prosecutor cannot prove a motive, and prosecutor cannot, if the prosecutor cannot motive, then even if the prosecutor proved that the perpetrator intentionally killed the victim, right? Even if the prosecutor proves the intent, proves that the killing was intentional and the killing actually happened, the defendant will be found not guilty, and because of the double jeopardy rule, the prosecutor cannot later charge with the second degree murder. So he is free forever. So it is very important that prosecutors choose the right crime to charge. If the prosecutor does it wrong the first time, doesn't get it right first time, there is no second chance. So so let's say I killed someone, and let's say there is just a videotape of me killing someone intentionally, right? The prosecutor still has to prove why I did it, why I hated that person so much, what I could gain from it. If that's not proved, the prosecutor can only charge with the second-degree murder. So, and again, motive has to be proved beyond reasonable doubt, right? Let me see. 그치. 여기. What is proof beyond reasonable doubt? I mean, I'm kind of making a detour into criminal procedure, but I'm going to come back to criminal law. Proving something beyond reasonable doubt means something like this. Let's say there is a crime scene. Someone is found dead, right? And then there are these, some devices, guns here, let's say wine glass here, right? So the total set of circumstances found at the site of crime, right? And then there is a defendant. And then there is like several scenarios that can explain this result, right? Let's say there are like several scenarios that are consistent with the result like this, including the defendant. And a reasonable person should not have any doubt that any of this is possible. Okay? Only then proof beyond reasonable doubt is achieved. So you can see this is a very, very high proof, high level of proof. If any reasonable person has a doubt that, the crime might have happened through scenario A, then the defendant has to be acquitted. Defendant has to be found not guilty. Now, it applies to the motive too. Let's say it's the same defendant, and prosecutor knows that defendant might have motive 1, or there's another scenario that defendant may have another motive. Even here, the prosecutor has to prove beyond reasonable doubt that it is motive 1, not motive 2, or motive 2, not motive 1. Has to pick a motive and has to prove beyond reasonable doubt that a scenario involving the defendant but involving another motive is beyond reasonable doubt. Okay? A reasonable person will not have a doubt that, defendant may have another motive. Okay? If a reasonable person has that doubt, then there is no proof of a crime. Defendant has to be acquitted. So proving motive is a very important thing in a crime of first-degree murder. All right, let's go back. Second-degree murder. All murders other than first-degree murder are second-degree murder, and manslaughter is two types: voluntary manslaughter or involuntary manslaughter. So I told you that manslaughters는 과실치사인데 involuntary manslaughter만 그렇고 그러니까 involuntary manslaughter만 과실치사에 가깝고 voluntary manslaughter는 even if it's intentional killing, if there's a reason to if there are extenuating circumstances, 그러니까 정상 참작할 그런 상황이 있으면 it is called voluntary manslaughter as opposed to second degree murder. What are those voluntary manslaughter situations? Mistake on self-defense or provocation or coercion. What's meant by mistake on self-defense? If self-defense is proved, then the defendant is, not guilty. But what if the defendant was mistaken about whether he was in a self-defense situation, right? He thought he was threatened with a gun, but he was mistaken whether the gun was loaded. Okay? Then, yes, you intended killing the person who was threatening with a gun, but he didn't know that he was just, the defendant didn't know that the victim was just joking, right? So it is an intentional killing. So it is murder, okay? It is murder, but because of this mitigating circumstances, because this extenuating circumstances, it's downgraded to voluntary manslaughter. Okay? So this is one reason why you cannot call manslaughter just 과실치사. Okay? And let me just finish. Provocation is when you are, provoked into uncontrollable anger. So typical situation of voluntary manslaughter was, excuse me, but this is true. A man who finds his wife cheating on him right at the scene, right? He was considered to be in a heat of passion, uncontrollable heat of passion. So when he kills the or the wife, it was often considered voluntary manslaughter as opposed to murder. The idea was that he was provoked. Of course, it applied to women, killing her spouse, cheating on her as well. Okay? And coercion is when you are coerced by, other criminals to commit something. Okay? All right. Your question.
So every murder that had a mistake on their self-defense,
Mm-hmm.
had a mistake on their self-defense is punished by the voluntary manslaughter, or can those mistakes be 그 착오가 합리적이면은 무죄로도 될 수 있는 건가요? 그러니까 정당 방위에서
그렇죠.
그 사실에 대해서 착오를 했다면 이제 그 이격이에 들어가는 거잖아요. 근데 만약 그 착오가 합리적이라면은 그게 무죄가 될 수 있는 여지가 있죠.
네, 그럼요. Yeah. If the mistake was reasonable, right? Then yes, it will be. But when the defendant fails to prove that the mistake was reasonable, he will be charged and punished as punished under voluntary manslaughter. Okay. Yes. What is?
The first degree murder and second degree
Uh-huh.
murder, is there a law?
Punishment, yes, differs.
There's a law.
A lot. So only in the first degree murder there can be capital punishment. Okay. So that's another consideration that the prosecutors have to think about, because there are a lot of people who have conscientious repulsion against capital punishment, right? Then when the jurors are picked, it's the same jurors who will decide on the guilt and the sentencing, right? So if the juror has a conscientious repulsion against capital punishment, that juror will be very hesitant in finding the person guilty. Because if the juror finds the defendant guilty, then guilty of first-degree murder, then he is in the risk of being decapitated, right? So, charging first-degree murder always carries the risk of alienating some jurors who don't like capital punishment. Anyway, this is something that's just interesting to make you remember things more. All right, property crimes. Larceny, taking away of another's tangible personal property with the intent to permanently deprive. Larceny is same as theft. Okay? Embezzlement, taking away of another's tangible property in one's possession with the intent to permanently deprive. Robbery, larceny from another's physical person by force or threat of force. Extortion, larceny by threat of harm. Blackmail, when the harm is on reputation. So extortion, blackmail, similar. It's just that on blackmail, the threat is on ruining the reputation. While in other extortions, the threat is on the body of the victim, right? Burglary, breaking and entering of a protected structure with the intent to commit a felony. Arson, burning of a protected structure. All right, any question, comment on this? I mean, you all know, you learned the criminal law, so yeah.
So in the American law, they don't distinguish the property and 재물상. 그러니까 그 한국 법에서는 재물과 재산상 이득을 구분해서 그거를 표제하고 있는데 미국 법에서는 그런 구분이 없는 건가요?
예를 들어봐.
그거죠.
소명이랑 배임이랑 구분을 할 때 재물인지 재산상 이익인지 차이가 좀 큰 차이가 되는데 예를 들어서 그런 부분이
배임이라는 범죄가 뭐 있는지는 모르겠는데 1학년 때 안 배워요. 1학년 때 안 배운다는 거는 메이저 크라임이 아니라는 거예요. 그래서 배임 상황이 되면 보통 이제 이사들 배임, 그 회사의 이사들 배임 상황이 되면 주주대표 소송 같은 걸 하죠. 민사로 해결하지. 이게 형사로 가는 경우는 없어요. 횡령이 있으면 그거는 처벌이 되는 거고. 그래서 재물의 경우에만 형량이 적용된다 이거죠. 재산상의 피해를 주면 배임으로만 할 수 있고 그런 취지죠. 근데 배임은 자기가 안 가져도 되잖아, 그지? 횡령은 자기가 가져가야죠. 여기서 형법 공부하고 있어. 여튼 그런 범죄가 있다라는 걸 기억하면 되고, 그러니까 자기가 가져가야죠. 그래야 인베스트먼트죠. 또는 뭐 자기가 아는 사람 한테 가져가거나. 근데 그게 재산상 이익. 근데 재산상 이익이라는 거하고 재물이라는 거하고 제3자냐 당사자이냐 하고 다 연관되어 있는 것 같은데 아닌가? 재물은 여튼 복잡하다. 네. 우선 진도 나가고 시간 나면 또 얘기해 봅시다. 자, preliminary vicarious. Intent alone, not a crime. Solicitation, crime. Conspiracy, crime. Attempt a crime. And on top of that, being an accomplice is also a crime, right? So, aiding and abetting. 그러니까 공범은 이미 다 알고 있죠. 공모, 미수, 교사, 이건 다 별도 범죄인 거 다 알고 있죠. 공범만 이제 정범이 있으면 정범을 도와준 것에 대해서 종속적으로 처벌하는 거고, 나머지는 다 별도의 범죄들이고요. 사후 공범은 이제 그러니까 여기 accessory before the fact, accomplice, accessory after the fact, 이건 다 이제 그 방조의 시점에 따라서, 방조가 언제 이루어졌냐에 따라서 나누는 거고. 자, 질문 있습니까?
간접정보 개념은
간접정보는 뭐예요, 근데?
그 의사 없는 사람을 시켜서 막 하는 경우 자기가 죄송해요 1학기 때 모이라서
그건 그냥 공범이라 해야 되는 거 아닌가? 의사가 없는 사람을 시키는 거? 그건 교사범 아니야?
교사보다 더 세게 완전 정범으로
아, 그런 거는 잘 못 들어본 것 같은데. 네. 대신 이제 그게 있죠. 간접정범, 공모공동정범이라고 부르는데 우리나라에서는. 공모공동정범은 이게 왜 만들어졌냐면은 공모는 서로 공모를 이렇게 계획을 해야 이제 공모가 발생을 하는데, 그런 공모가 실제로 없는 경우, 그래서 암묵적 공모라고 하죠. 암묵적 공모. 그러니까 있는 사람도 이제 공모 한 것으로 처벌하고 싶어서 만든 거죠. 그래서 예를 들어서 조폭에 이제 부하가 있으면 조폭이 뭐 X라는 사람 죽여라라고 시키진 않았어도 어떤 그 조직의 목표 자체가 X라는 사람을 죽일 수밖에 없는 상황이었으면은 실제 죽인 사람은 부하인데 그 두목까지 정범으로 처벌하고 싶다. 예. 단순한 교사범위도 아니고, 아니 교사도 없지. 왜냐하면 누구 죽이라고 한 적이 없으니까. 근데 그 X라는 사람을 부하가 죽인 거에 대해서 두목을 정범으로 처벌하고 싶을 때 이제 공모공동정범이라고 하죠. 그래서 이것도 미국에서 온 건데, 미국은 racketeer influenced racketeer influenced crime인가 criminal인가 하여간 organization. 그래서 RICO라고 불러요. RICO. 그래서 racketeer influenced criminal organization은 뭐냐면은 이제 범죄 조직을 말하는 거예요. 범죄 조직. racketeer influenced. 지금 그냥 검색을 해보세요. 리코. 네. 그래서 이거는 어디에 보면 잘 나와 있냐면 배트맨 그 나이트 시리즈 중에 하나예요. 나이트 라이즈스인가 나이트 라이즈스인가에 보면 그 마피아들을 이제 척결하기 위해서 리코를 이용을 해가지고 이 부하들의 범죄를 두목들한테 다 씌우는 장면이 나와요. 불행히도 여러분들이 볼 퀴즈 때 볼 영화는 배트맨은 아닙니다. 자, 넘어갑시다 그러면. Okay, criminal procedure. Criminal law protects public interest, not just private. So prosecution must go on no matter what. Okay, so what is criminal law? Criminal law protects, criminal law is the last resort in protecting people's lives, health, and properties, right? So protecting people's lives and properties has to happen no matter what. But at the same time, people are protected by presumption of innocence, right? So criminal investigations done with criminal investigation is done for the purpose of protecting very, very important public interest, which is protecting people's lives and properties. So criminal prosecution and investigation has to take place right away. But at the same time, people are protected by presumption of innocence. So it creates this dilemma, right? Now, this person, suspect, is protected by presumption of innocence. That means he should be treated like any other person, right? His right has to be protected the same way as other people are, right? But what if he doesn't want to cooperate with the investigation? What if he doesn't want to stand the trial because he believes he is innocent? But there is this great public interest in putting him on trial, right? If the person wants to run away, okay, he's still presumed to be innocent. Can you really put him in jail when he's presumed to be innocent? No. But you have to, do criminal investigation. So what's the solution? Well, the solution is something in the middle. So they created this process called warrant, right? So warrant can be issued not when crime is proved beyond reasonable doubt, but a probable cause to believe that crime has been committed by the suspect is proved. Or when such probable cause is shown, right? So prosecutors in seizing a person, in arresting a person, although arresting someone is like punishing, right? If they are doing it for the purpose of making sure that he stands a trial, then the prosecutors can do it just by showing a probable cause to believe that the suspect has committed a crime. Doesn't need to prove beyond reasonable doubt, right? Just has to show a probable cause. And a judge has to agree with the prosecutors. Okay, only when a judge. Now, what's the significance of a judge? A judge is a a official. So he has, a civil responsibility to care for people's safety. And yet, although the judge is an official, he or she is independent of how well the investigation progresses. Judges will not be promoted for catching 1,000 criminals, right? There is independence. So judges have no interest in how well prosecution goes or how well investigation goes. So both search and seizure, both search and seizure of things and search of a person, seizure of a person, thing. So seizure of a person will be 체포 구속, right? Seizure of a thing will be 압수. Search of a person, search of a thing will be 수색. 그래서 크게 보면 이제 압수수색 영장이 있고 체포 구속 영장이 있죠. Now, I made the distinction between between two dilemmas, but both dilemmas are the same because you are infringing on someone's right when he is still protected by presumption of innocence. And how can you do that? Well, by showing probable cause to an independent official, usually judge, that this person may have committed a crime, or that this thing being searched or this thing being seized may be incriminating evidence. Okay. Now this is different from civil procedure, right? There's really no need to force anybody to stand a trial. Because if someone, doesn't want to stand the trial, then you can always the court can always issue a default judgment. Default judgment은 상대가 답변을 안 해가지고 승소하는 경우 있죠. 송달이 이루어졌는데 답변 안 해가지고 승소하는 경우. 그래서 답변을 해야 되는데 또는 문서 제출을 해야 되는데 안 하면은 민사에서는 어떻게 해요? 승소 판결하거나 작게는 그 사안에 대해서 그 자백을 의제하죠. adverse finding, 그러니까 불리한 사실 판단을 한다는 게 이제 adverse finding. 그냥 그렇게 하면 되는데 형사는 이제 그렇게 못 한다는 거죠. Okay, let's move on. So, who decides upon a probable cause? Independent officer, neutral officer, that's a judge. And then there is an extra protection for defendants facing government's awesome power, especially risk of torture. In the past, the governments of the world have abused their power to prove guilt on innocent people. So every year, the constitutions began protecting people from such abuse. That's why criminal procedure is, like 90% of it is actually constitutional law, because it's about protecting people's right in face of state's power. And state's power is exercised in the form of torture. Okay? So the first protection is proof beyond reasonable doubt. And I already explained what that is. Okay? It raises the bar. Okay? Now, the second is this one. Right to counsel and right to assistance of counsel. Also, right to silence. You can just write that in. Right to silence, right to counsel, right to assistance of counsel. What's the difference between right to counsel and right to assistance of counsel? Right to counsel은 변호인 접견권을 말하는 거고, right to assistance of counsel은 변호인의 조력을 얻을 권리. 우리말로 해도 차이가 잘 뭔지 모르겠지만, 변호인의 right to assistance of counsel은 변호사가 없을 때도 이제 무료로 국가가 제공해 줄 거를 right to assistance of counsel이라고 하고, 변호사가 있다고 생각하고 변호사와 소통하는 걸 막지 못한다는 게 이제 right to counsel이에요. And the question is, when do these rights apply? The right to counsel and right to assistance of counsel. Well, they apply in two situations. One is when there is a custodial interrogation. custody가 뭐예요? custody. 신병이라고 번역해요. 신병. 신병을 확보했다. 무슨 얘기야? 체포했다는 얘기죠. 네. 그래서 custodial interrogation은 이제 구금 상태에 신문을 하는 경우. 그러니까 고문이 하도 많이 일어나니까 고문이 언제 일어나는지, 고문이 일어나는 상황을 가장 간략하게 설명하면 바로 custodial interrogation. 그리고 또 하나는 indictment. 그래서 기소가 이루어지면, 기소라는 건 국가가, 적어도 행정부는 피의자가 범죄자임을 확신한다는 걸 보여주는 거잖아요. 확신을 보여주는 문서가 뭐예요? 국가가 저 사람은 범죄자다, 저 사람은 재판을 받아야 된다라고 확신을 보여주면서 재판을 시작하는 문서. 민사소송, 민사재판을 시작하는 문서는 소장. 형사소송, 형사재판을 시작하는 문서는, 형사재판을 시작하는 문서는 기소장. 네. 그래서 기소장을 indictment라고 부르죠. 그래서 우선 기소가 이루어지면 이 국가가 이 국가의 엄청난 힘을 가지고 awesome power 이라는 표현을 많이 씁니다. 국가가 가지고 저 사람의 이제 인생을 파괴하겠다 라고 선전포고를 하는 거거든요, 기소장은. 그럼 이제 그때부터는 그 개인을 보호하기 위해서 꼭 custodial interrogation 상황이 아니더라도 계속해서 보호가 돼야 된다라는 그런 법리가 있어요. 네. 그래서 우선 거기까지 말씀드리고 좀 더 자세히는 이제 좀 이따 얘기를 할게요. So, criminal procedure at a glance. It's there are three different procedures going in parallel. Usually one and two can happen before three. Usually one and two happen before three, but it doesn't have to be that way. Trial can happen first, and then arrest can come later. This is very important in understanding American criminal law, because this is where American criminal procedure in practice differs from Korean criminal procedure. the three processes have different goals and take place independent of one another. Now, the first one, investigation, search and seizure of evidence, and custodial interrogation. Okay? That's investigation. Search and seizure of evidence. 그건 이제 물증 때문에 그런 거고. 근데 이제 자백도 중요하잖아요. 그거 하기 위해서는 custodial interrogation. 하지만 search and seizure of evidence는 뭐가 필요해요? 영장이 필요해요. custodial interrogation은 뭐가 필요해요? limited by right to silence and right to counsel. 묵비권하고 변호인 접견권. 네. 그리고 또 하나의 절차는 arrest. If you look at American movies, you will see the police coming to arrest the suspects as if there is no tomorrow. They'll arrest the suspect on his or her wedding. They'll come, like if I'm a suspect, they'll come arrest me. They'll come in to the classroom and take me away, handcuffed, during class, right? Even like, Major League Baseball players, they'll be taken away during the game. As if there is, nothing more important. Arrest takes place in such expeditious manner. But you'll be surprised, the next day, he's already out. Okay? So people wonder, if he was going to be out on street the next day, why did the police hurry so much in, arresting him out of wedding ceremonies, out of World Series games, out of final exams? Yes, they'll take you out of the classroom during final exam. Okay? Why do they do that? Well, because the purpose of arrest is not investigation. The purpose of arrest is obtaining security, okay, or securing the power to have a trial on that person. That power has to be established, and in order to do that, the person has to be brought first into the custody, and only if he promises to stand the trial, then he will be released. And he does that in front of a judge. That's called hearing. And when he promises to stand the trial, and if his promise carries the day, okay, if promise convinces the judge, then judge releases him. Release in older English was called bail. So that's why it's called the bail hearing. So if the judge is not convinced that he will, if the judge is not convinced of the promise, then he will assign bail money. 우리나라로 치면 보석금이죠. 네. 그래서 미국은 보석 신청을 따로 하는 게 아니라 체포는 우선 돼요. 체포는, 그리고 미국은 뭐 놀라운지 모르겠지만 영장 없이 체포할 수 있습니다. 근데 체포를 한 다음에 하루나 이틀 안에, 그러니까 최대한 빨리 자기가 재판에 출석하겠다, 그러니까 사법 절차를 밟겠다 라는 약속만 하면, 약속을 못 믿으면 돈을 내야죠. 보석금을 내야죠. 약속을 하거나 충분한 보석금을 내면 반드시 풀어줘야 돼요. 그래서 구속수사라는 게 없죠. 네. 구속수사라는 게 없고, 그냥, 이 사람은 너무, 엄중한 처벌을 받을 상황이기 때문에 도망갈 수밖에 없다라고 해서 이제 보석이 기각되는, 그러니까 보석되지 않는, 피해자가 있을 뿐이지, 특별히 어떤 다른 구속이라는 절차가 없어요. 모두가 체포가 되면 우선 끌려오고 보석되지 않으면, 그러니까 석방되지 않으면 그건 그냥 우리나라 구속하고 똑같이 되는 거예요. 근데 여기서 중요한 거는 잡히자마자 곧바로 풀어준다는 거. 그러니까 풀어주는 게 원칙이라는 거. 왜? 잡고 있어봐야 묵비권을 행사하면 아무것도 어차피 얻을 수가 없어요. 그 경찰이 그걸 알기 때문에 잡고 있는 것에 어떤 애착을 가지지 않는 거죠.